Hello, this is Chris Ferrara, and this is the inaugural episode of a new series, Church and State, which will explore developments in the church and in the state, and often the relationship between the two. Today's subject is a lawsuit entitled Seuss versus Cuomo. In this suit, in which I was the lead counsel for plaintiffs, we were suing the Governor Cuomo and Mayor de Blasio and the Attorney General of the state of New York in connection with the governor's COVID-19 lockdown regime. You will know from following press accounts of these lockdowns that they involve restrictions on gatherings, both indoors and outdoors, setting the number of people who can gather outdoors and the number of people who can gather indoors, and also telling people which businesses may operate, which businesses must close, which businesses can sell which products, who can do what, where, and when. Virtually every aspect of people's lives is being regulated under these lockdown regimes. Our suit waged a challenge to the COVID-19 lockdown regime because we argued, successfully as it turned out, that the lockdown regime discriminated against religion in a couple of ways. First of all, indoors, it set gathering limitations of 10 people at first, which means for Jewish worship, on behalf of the Jewish plaintiffs, that it was impossible to have a Jewish congregation because they have to have a minimum of 10 adult males even to begin their services. This is called the minyan. The male minyan is the equivalent of the male priesthood in the Catholic Church. So effectively, the 10-person indoor limitation made it impossible to have a Jewish congregation. In upstate New York, we represented two Catholic priests, Father Seuss and Father Stamos, who ministered to 3 different churches, and the 10-person limitation there made it impossible for them to conduct normal Sunday masses or even daily masses. Depending upon which type of mass you were conducting, a high mass or a low mass, and the number of altar servers involved, it would have to be numerous masses, 5, 6, 7, or 8 masses on a Sunday, and on other days as well. So Catholic worship was impermissibly burdened by these gathering limitations. In the middle of the lawsuit, something happened. The governor decided, and Mayor de Blasio decided, that it was perfectly permissible, despite all of their regulations of gatherings, for thousands of people to protest the death of George Floyd, including demonstrations that spanned the entire length of the Brooklyn Bridge and the Manhattan Bridge, that filled Cadman Plaza. In that case, Mayor de Blasio personally addressed the gathering, not wearing a face mask. What the governor did and what the mayor did in that case was to abolish their own outdoor gathering limitations. We brought this to the court's attention. The court recognized there was a double standard at work and eliminated the outdoor gathering limitations because the governor and the mayor and other public officials had just ignored them. So effectively, they themselves abolished the outdoor limitations. Turning indoors, the court reasoned quite simply that if you're going to allow various favored businesses, including restaurants, to operate at 50% of indoor capacity, and restaurants would involve tables of 10 under the regulations, people facing each other, eating, talking, laughing while facing each other, spreading the virus much more effectively than they would in a church service, then the court reasoned churches should be given the same indoor capacity limitations. But under this scheme in New York State, churches alone were relegated to 25% indoor capacity. The court struck that down and said they are to be given the same indoor capacity limitations as the favored businesses in phase 2 of the governor's plan for reopening New York, so that it stands at 50%, and when these phases move into the 3rd and 4th phase, the churches will move along with them instead of being in a ghetto where they alone have 25% indoor capacity. So it's a tremendous victory for fairness in the application of these lockdown regimes, and that's what the case is all about. Now, let's talk a little bit more about the plaintiffs in these cases. The plaintiffs, as I said, were 2 priests in upstate New York. They had ministered to 3 different Catholic chapels. They, unlike the mainstream Catholic priests and bishops in the state of New York, were willing to take up the challenge to the COVID-19 lockdown regime because they aren't beholden to the mainstream ecclesial establishment. So they had the courage to come forward as plaintiffs, both Father Stamos and Father Seuss, and they were successful. In a unique alliance, this case also involved 3 Orthodox Jewish worshipers in New York City, where the double standard I've just mentioned was particularly egregious. Let me give you one example. On the same day tens of thousands of people were marching through Brooklyn to protest the death of George Floyd. The police were rousting about a dozen children, Hasidic children in an Orthodox Jewish neighborhood, from a little park in that neighborhood. The double standard was preposterous, of course, and the court saw that. So, the evidence and arguments we presented in the case were simply these points. First of all, you can't justify mass gatherings by protesters, and also these were later extended to include Juneteenth celebrations, while tightly restricting the outdoor gatherings for people engaged in religious and other gatherings. And the court recognized that. Some of the evidence we presented was photos of thousands of people thronging the Brooklyn Bridge, thronging the Manhattan Bridge, packing Cadman Plaza. Now, the governor, and other evidence that we cited, was confronted with this disparity. He was asked point blank, how can you allow thousands of people to march and gather in plazas and streets in New York City while you prohibit a high school graduation ceremony? The reporter asked the governor specifically about a high school graduation ceremony that a Pakistani immigrant family wanted their child to attend. And the governor, as we pointed out in our papers, literally sneered at this reporter and basically said, well, you know, we can't permit high school graduations because people will die. Do you get that? He said, people will die. Have you been listening to what I've been saying? He said, for the last 96 days. Well, he'd been saying for the last 96 days that we can't have small gatherings like a high school graduation because they kill people, but somehow 25,000 people marching across the Brooklyn Bridge posed no health threat whatsoever. That kind of evidence really destroyed any public health rationale that the governor might have had for his outdoor gathering limitations. Turning to the indoor gathering limitations, we presented such evidence as the following. If you limit indoor gatherings to 10 people, you can't have a Jewish congregation. You have to have 6, 7, or 8 masses on a Sunday. And one of the ironical things we noted is that in the Jewish neighborhood of Brooklyn, where the indoor person limitation was 10, the bagel store across the street from the synagogue was packed with people, and there was a line halfway down the block to buy bagels. So under this ridiculous reopening plan, the purchase of bagels is considered essential, but the worship of God is considered a non-essential gathering. That's the very term Governor Cuomo used, and so is relegated to the status of 10 people indoors and no more. This was later expanded to a generous 25% of indoor capacity, and the judge concluded that that is discriminatory because houses of worship alone were limited to that indoor capacity. So because of that discriminatory impact based on the evidence we presented, the judge basically equalized the standing of houses of worship with the standing of such businesses as bagel shops, grocery stores, and the like. So what is the lesson we learned from a case like this? We learned that the use of executive power to declare a health emergency has its limits, and the limits are established by the First Amendment to the United States Constitution. As the court observed in this case, there's broad discretion on the part of executives in cases of health emergencies like this, but when that broad limit is exceeded by a palpable violation of constitutional rights, the judiciary must step in and remedy the situation, which the court did in this case. So the lesson to be learned is, if there are people who have the courage to stand up to the high and mighty, to the powers that be, in a kind of David and Goliath scenario, and file a lawsuit, if you get a fair-minded judge who considers the evidence dispassionately, you can achieve justice against the high and the mighty. And that's what happened in this case. Now, another lesson we can learn is that these lockdown regimes represent a paradigm that should alarm every American. The paradigm of what they are now calling the post-COVID world. It seems that the forces that conspire against religion and moral values in American society are using the advent of a virus to install a lockdown regime that basically suppresses religious activity. And if this paradigm is allowed to stand unchallenged, it will no doubt be employed again in the future. We're already hearing talk about a virus, a swine flu, that is newly emerging in China, If we allow this paradigm to stand without challenge, there will be another lockdown. In fact, even this particular virus, they're claiming, is resurging. What do they mean by that? They mean simply that they're testing now that people have come out of their houses and finding more and more asymptomatic cases. But they're trying to panic people by talking about an increase in the number of cases to keep fear alive, to keep people subjected to these lockdowns. And this will happen not only in this case, but again when the next virus comes around. So it seems that unexpectedly, out of nowhere, we have pop-up dictatorships based upon the emergence of novel coronaviruses or the next swine flu or whatever health emergency they can conjure up that have accomplished a lot of the aims of certain political forces that they were unable to accomplish at the ballot box. And we see these lockdowns ramifying into various other demands of the American left. Mail-in voting. It's just too dangerous to go vote, they're arguing, even though 25,000 people don't think it's too dangerous to march across the Brooklyn Bridge. They're saying that we need all kinds of other social reforms, and there will be a new world. People will never again be allowed to gather in certain ways and for certain purposes. All of these things must be tightly restricted by government going into the future. And so what we have here is an exercise in social engineering, and our only recourse is going to be the courts, which is why it's essential that people be prepared, when necessary, to stand up to these abuses of executive power, the so-called emergency powers of governors and mayors, and challenge them in the courts. Those courts are going to be our last defense in defense of religious liberty. And with that, I will conclude the first episode of Church and State.